Well, once again, my name is Larry Forman, and I'd like to start with a basic question. By show of hands, how many of you all think that you have rights when you're out driving in the road? That you have rights when a police officer stops you? Now, how many of you, by show of hands, think you have no rights at all, whatsoever? Not a single hand went up. Last presentation, we did have a hand or two. You guys are all wrong. You have no rights whatsoever when you're out there driving around, okay? A police officer pretty much has a carte blanche to do whatever they may. Now, most of them will not veer away from their training. They will stick to a routine that they've been taught for safety purposes, for protecting the record purposes. I mean, especially if you're violating the law, they want to lock you in. They want to make sure that they notate exactly what you did, what time you did it, and any kind of field notes that pertain to you that they can share with either the defense attorney, the prosecutor, or whoever it may be. So when an officer stops you, the first thing, I'll just throw this back at you. What do you think is the first thing you do? So you just pulled over to the side of the road. What is the first thing that you think a person should do?
Like us?
As a person, as the driver. I'm sorry. I
Turn the vehicle off.
Turn the vehicle off. I like that. What else? What's
Grab your
next?
license.
Grab your license and your insurance.
See,
Your
the
hands on
officer,
steering wheel. Yeah.
you have to keep in mind, remember that if you can understand the psyche of the police officer, you can ease his job and maybe even get out of the ticket. What do I mean by that? So, let's present a scenario where you're completely sober, and you're driving around, you ran a red light, maybe you did, maybe you didn't, but he thought you did. That's all that matters. So he stops you, pulls you over. The first thing, with regard to shutting the engine off, I'm on the fence of that one. It's good, but you don't have to. He's not going to go apeshit just because your engine's still running. But the first thing, at least unless it's like really, really cold outside, I recommend rolling the window down, or if you got one of those automatic ones, and sticking your hands out the window. Why? As I was saying, if you understand the officer's mentality, what is he thinking? He's thinking only one thing. Who are you, and am I safe? Safety is his number one priority. So if you can make him as safe as you possibly can, you're already on the same playing field. Even though he is approaching you thinking you violated the law and he's about to write you a citation, a ticket, a warning, or something, if you are able to show him that you care about his situation, if you will be, at least in that regard, on the same side. I've actually, a couple weeks ago, I got pulled over and I did this whole thing, and I'm very cool with the cop. I mean, always, officer, my wallet is over here in the middle console. Can I open that? I mean, I promise you I have no firearms or drugs in there. I actually said that. Do not attempt. Leave it to the professionals. And then when you go to the glove compartment, I don't know if any of you conceal carry. I do not have anything in there. My registration is there. May I open it? And it makes him feel like you're part of the team. Okay, and he's not gonna. I actually got off with a warning just because of that. Now, I knew clearly that I read that red light, but you never admit that to the officer. Come on. So, now let's change the scenario just a little bit. You just were at a bar 2 hours ago. You had one glass of wine. Maybe some food, maybe no food. But there's a little bit of a hint of alcoholic beverage on your breath. And if the officer detects that, he has a trigger in his mind. So a traffic stop plus alcohol becomes an automatic DUI stop in his mind. There is no, oh, officer, it was just a beer 5 hours ago, even if it really was. To them, the game has changed. These are not the 1980s or early 90s anymore. Because back then, I've heard stories how a cop would stop you and then drive you to your house, drive you to a friend's house, or let you even sleep it off. Those days are gone. And they will immediately begin processing you as a DUI stoppee. So what does that mean for you? He will begin with a few questions. All he needs is an answer of yes to at least one. Have you been drinking tonight? If the answer is anything but absolutely not, you just turn into a DUI stop. So now he's going to go into a whole string of things that he has to do that he's been trained on. The first thing, and sometimes they switch it around, the first thing usually is to get what's called a PBT. It's a preliminary, not portable, even though they are portable. They're called preliminary breath tests. And he will bring it out of his belt and ask you to blow. Now, two things with that. If you really think that you're going to be under that .08, I would not recommend it. I would not, because those things are very, very not accurate. They're not very accurate at all. And sometimes even just, because they test your breath on a molecular level, on a very, very, like tiny, tiny particles. All you need is a couple of particles to go through, and that will test maybe above what you actually are. But you will never know, and he will never care. So I always recommend not blowing unless you really have not had anything to drink whatsoever. But by virtue of refusing the PBT, he cannot do anything legally. Now, he may still, that may raise his suspicion because he's already biased. Again, you're already in that DUI stop zone. But because there's no legal ramification for you refusing the PBT, basically. It's in the statute. The PBT number is not admitted. You can blow a .3 on a PBT. That number cannot come in court. KRS 189A 103 or 104. It does not come in. Now, you refuse, he may start thinking in his mind, well, why did you refuse? If you really are fine, and I just smelled alcohol and you think you're fine, why aren't you blowing? That's what was going through his mind. The next thing he will ask you to do are the field sobriety tests. Has anyone heard of these, the field sobriety tests? There are 3. There used to be like 7, 8, or 9. There's like the alphabet test, the finger count test, the drop a quarter on the ground, pick it up. Some counties, God bless their hearts, still use some of these tests. They are not official. The NHTSA, National Highway Traffic and Safety Administration, they have a manual that has standardized the field sobriety testing process, and now there are only 3. There's the there's the horizontal gaze nystagmus, which is also known as the follow my finger test. There is the walk the line, where you have to walk 9 steps, heel to toe, from one end to another, and then turn around and then go back. And then the third one is the one-leg stand, where you're supposed to hold your foot up about at least 6 inches off the ground and maintain this. Some people say it's 30 seconds. It's actually not 30 seconds. It's until the officer feels that he's considered you done, basically. I've seen them hold their foot up as long as 50 seconds because they're waiting for you to mess up.
I don't know what shoes I have on.
I know, right?
Thank you for bringing that up, by the way. Shoes are very, very important. It is also important for the officer to let you know if you're wearing, ladies, you're wearing high-heeled shoes, heels, 2 inches or more, which, by the way, I've never seen anyone be able to keep their balance on even a 1/4 inch heel, like properly. But the manual states 2 inches or more, the officer must give you the option of removing your heels if you so choose. Now, I think the same should be applied to flip-flops and any other kind of footwear that is kind of fragile or can be slipped off and whatnot. But it's not done, and we later get to have our fun day in court. But with regard to most of these field sobriety tests, if you're at least 50 pounds overweight or over the age of 55, you're not supposed to be doing, because it's 65, you're not supposed to be given these tests to begin with. Now, let's come back to our stop. The officer just offered to give you field sobriety tests. If you say, officer, I refuse to do field sobriety tests. Again, it's a double-edged sword, because one, you're now raising his suspicion even more, because he's used to people complying. If you're not compliant, to him that raises red flags for his training. However, once again, statutorily, the statutes don't even mention field sobriety tests whatsoever. Yes, it's evidence that's admissible in court, that's the easy part. But if you refuse to do them, there's no evidence, there's nothing to admit, there are no consequences, no repercussions, nothing. So you refuse, the only real consequence is on the street with the officer right there, raising his suspicion. So, in a real life scenario, luckily I've never had to go through with it. I did get a breathalyzer when I was in college a couple of times, but I didn't drink, so I blew into it, and that was the end of it. But I really do wonder if an officer asks you to do all these things, and you're not totally reeking of alcohol. What his reaction would be, because arrest is a little too the stopping part is the easier part for him to overcome. That's reasonable suspicion, as it's known. That's the standard. In order for a stop to turn into an arrest, requires an elevation in that. Probable cause is required, not reasonable. So you cannot arrest somebody for reasonable suspicion of violation of the law. So if an officer offers you a PBT, you refuse that. The officer offers you field sobriety test, you refuse that. You give him your license registration. If he asks you out of the vehicle, you exit the vehicle. There is no, I'm not exiting. There is no, I get to keep my ID. Those things have been ruled on. Yes?
You're talking to a room full of ladies, and maybe I missed it. Did you say that I'm not going to get out of the vehicle unless they identify themselves? Do they not have to show you who they are before you get out of your car?
When you say show, is the uniform
Like
insufficient?
if they're not in a uniform.
If they're plain clothed, then I'm with you. I would actually be, in that situation, that's an excellent question. In that situation, I would say, officer, if you don't mind, I would like to call 911 myself and have a uniformed officer in a marked car present, if you don't mind. Now, if he's going to raise hell, now you're starting to raise red flags, going, wait a minute, I'm not really comfortable with this situation. I still wouldn't recommend driving off, but, you know, it's a case-by-case analysis in that regard, I guess. But once the officer goes through his whole rigmarole, he has to have something more. So if he asks you to exit out of the vehicle, again, their fallback is always, just think the S word, the other S word, safety. If there is a safety argument on the police officer's end, then you must comply. If there is not, then maybe you have an alternative option unless there's a legal ramification for it, which we'll get to in just a moment. Before we continue, I just want to stop right here. Does anybody have any questions at this juncture?
Going back to when you got stopped, sorry.
No, you're fine. Go ahead.
Going back to when you got stopped, okay, so you said that, assuming you don't have concealed carry. If you do have concealed carry, what do you do?
If you have a concealed carry, inform the officer that you're carrying a weapon and that where it's located. And I think, Patrick, you probably know this a little bit better.
You have to state that there is a firearm within the vehicle, where it is located, and whether or not it is loaded or not.
So that hasn't changed from when, okay.
And what about, do you have to present the license?
license.
And you do have to,
The concealed carry license, okay.
whenever you hand the license, your driver's license over, it has to be with it.
Got it.
You might be getting to this,
Go ahead.
but what happens if you refuse everything?
If you refuse everything, the officer still has really two options. Let you go. It is the easy one. But if he is sufficient, I mean, here's the bad part. If you haven't slept in like 14 hours, you've been working all day, you're tired, your eyes are bloodshot no matter what, and if you had a drink that is still maybe has enough of a scent where he detected it, he's probably not going to let you go. Probably not. Again, it's on a case-by-case basis. Like I said, all he needs to hear is, I've been drinking. 3 hours ago, I mean, he's used to, or she are used to the fact that people lie. They'll say anything just to get out of it. So, let me just finish answering that question. So, the second option that he has is to let you out of the vehicle, even though you refuse the field sobriety test. He's still going to want to see, like, are you going to be standing there like this? Are you going to be leaning on the car and then slowly kind of drooping off the car, you know? So if he's got that, then he's, I'd say, pretty close to probable cause at that point, especially in a DUI situation. But if he can always call, he can keep you there for about 3 hours. If he's going to suspect drugs now, you got something else, he's going to call the canine unit in. I mean, I've seen that happen. So they have ways to keep you where they want you, lawfully, unfortunately. But will he just arrest you because you refused everything? That's not enough. Refusal to comply does not equal probable cause. Because otherwise it's like, blow into this. You blow, probable cause, you're under arrest. Blow, I'm not going to blow. Probable cause, you're under arrest. Like, come on.
Right.
That's a catch-22. So those will not.
So if
if you know you haven't been drinking, you can just be like, no.
You can. If you know you haven't been drinking, I just blow it just to give it,
What are the
show what a dumbass he is.
What are the chances that, I mean, given its inaccuracies, that it would indicate there's something on it? Or that, I mean,
If there's absolutely
it
no
sounds bad,
alcohol,
but what if they just say, oh yeah, it says you have?
they're supposed to hold it up at least to the camera. Usually they won't tell you what it is, but if you're over, they'll tell you that you blew a .12 or something, Sometimes they'll hold it up to the camera. Sometimes they'll just write it on this. Again, because of the fact that it's inadmissible, even if, it's only admissible for purposes of showing probable cause for arrest, naturally. That's the obvious
Okay.
one. I arrested her because she blew a .09.
So if you know that you haven't had anything,
Blow?
then
By all
just
means.
do it, and if there's no risk,
Yeah, you'll look at it,
it'll
you'll say,
read
well-
something if there's nothing.
She's just tired, yeah.
Okay.
Get a
Is there-
hotel, don't drive.
Is there anything that affects that, like gum or medication?
NyQuil.
Anything that has alcohol in it.
NyQuil.
Oh, NyQuil, absolutely. NyQuil is a big one for teenagers. I know that, they'll take some NyQuil because they have a cold, and then, I mean, it has a bit of an alcohol smell, after smell, on your breath. So they will, because the legal limit for under 21-year-olds is .02.
What does that mean, .02?
.02 is
How much alcohol does that indicate?
that's 80 milligrams per 200 liters of breath. Well, in this case, it would be 20 milligrams per 20 milligrams per 200 liters of breath. So that gives you, you know what 200 liters is? You ever seen the 2-liter bottles of Coca-Cola? That's 100 of those. So that gives you an idea of how much capacity is being calculated in a tiny little chamber in the machine. And I'm sorry, was that your question? I keep trying to
So
get
probably
back.
for a 16-year-old girl, a couple of beers, I put them at probably .02.
A couple of years to put them on that.
Way over.
Oh,
It should be
yeah.
about a .04, .05.
Oh, okay.
And mass, so a few things affect the number that you will generate. Your weight. By the way, for the record, tolerance plays no role. You can be an alcoholic needing a bottle of vodka to get drunk. You will blow above and beyond any other person, but I didn't feel it, officer, is not a defense in court. So the weight, the height, the age, not so much. How much food you had. Are you drinking on an empty stomach? What kind of food did you have? Was it just a garden salad, or did you have like a burger with lots of bun to absorb some of that alcohol content? And age, height, weight, sex. Actually, males I think require just a little bit more than females do to get the effects. For the exact same amount of alcohol, a female will blow just slightly higher. Even if everything is the same, I mean, height, weight, let's say age. Males, for some reason, blow a little bit. I think it has something to do with the spleen. I read this a long time ago, I don't remember. But you had a question, my dear.
Well, I'm kind of a bottom line gal, so what I'm hearing is there is no more have a few drinks, talk your way on down the road. They're being very serious. So basically, anybody that has a drink, given all the factors you just shared, sex, weight, which you've eaten all that, you're susceptible to a potential DUI for stopping.
Absolutely.
That's the bottom line.
Yes.
You've also said that the test, the blow test or whatever it's called, is inaccurate.
Yes.
Okay, so that is a civilian.
It's not always accurate.
Uh,
It's not always accurate. It's very susceptible to if you have a cold, your body temperature will rise. It's
That's why I
calibrated.
said it's inaccurate. It's
Yes.
really not, really admissible. There's no sense in doing it. So if you feel that you've hit all these criteria, can you just call your attorney while you're at the post and, instead of going through all this rigmarole?
You laugh. That would be the most brilliant thing that you have ever done.
That's what I'm thinking.
Sure.
Because most
You mean
people,
like as soon as he gets to jail?
Or as soon as
No,
you
no,
pull
no.
over.
while you're in the vehicle, there's absolutely no reason to tell the officer, I'm not in violation of the law. I mean, just say something. I mean, I don't know. You don't have to, but say, officer, I would like to speak to my lawyer. If your lawyer can get there in time, by all means. They can only keep you there for so long. Per Terry versus Ohio, that was the whole, I don't know if you guys ever heard of a Terry stop. That's, the Terry stop is everything that the officer needs to accomplish must be accomplished within a 15 to 20 minute time span while you're there pulled over, unless he has reason for something like a drug stop or an alcohol stop, then he can keep you longer, because now he has reasonable suspicion of not just a traffic offense, but a violation of the law. And that gets a little more hairy, but just a regular stop cannot be longer than 15 to 20 minutes. And if you exercise your right to have your lawyer present or speak to your lawyer, by all means, I highly, highly recommend it.
So what's your response time?
See? You just put the ball in his court, it's back on him. He's got,
No.
the clock is ticking.
We're talking about
Oh, my
you.
response. Depends if I'm on vacation or not. So anyway, let's go back to the scene. So let's say our poor driver is getting arrested for DUI. He or she is handcuffed, put in the back of the cruiser. And by the way, if you see a dash cam on the officer's cruiser, he's recording everything that you're doing outside of the vehicle. If you're ever in the back of the cruiser, he turns that puppy around, and it's now facing you. And it will detect facial expressions. Everything you say is being recorded. Now, if there isn't one, they don't have, to my knowledge, they've never seen just like a microphone in the vehicle. It's usually just a camera, and if there is none, there is no audio.
Where's it positioned normally? Because I don't hang out with the police department, so I don't know where they'd have it.
It's right there where most people would keep their GPS. Right there on the, yes, Patrick?
The dash cam is mounted to the passenger side sun visor, hangs down. It's an arbitrator system, and it is a wireless mic attached to the police officer himself.
Sometimes, not always.
And LMPD is.
Yeah?
Yeah.
Okay.
And would this mic be in plain sight for us to see?
Nah, it's
The new
small.
ones, they now have,
It's
they're
small
now
and
putting out
black.
these video, they're called body cams now. So it's going to be a little camera, you're definitely going to see that. It's going to be a little camera that's going to be recording everything, including the interaction at the curbside with when he approaches your vehicle. That's the new thing that they're rolling out right now. So that's, seriously, this is like a month old, if that even, maybe 3 weeks ago. They kind of announced it that they're finally doing it. So our poor driver is arrested. He's being taken to the station. When you'll arrive at the Sally Port, and you'll be taken to this fairly small room, concrete room, called the BA room, is what they call it. It's BA because it's the blood alcohol. And there you'll be confronted with the BA tech, the breath analysis technician. And this gentleman or woman's job is to do a few things. Number one, they must read you your implied consent. Oh, and by the way, let's back up for just a second. I get a lot of questions. I haven't gotten this one yet from this crowd. Miranda. Can an officer arrest me before I'm Mirandized? And they didn't read me my Miranda rights. Miranda is a prophylactic tool. It basically, for the most part, it is completely useless. Okay. Miranda is only going to assist you if you make incriminating statements, and they've been coercing those incriminating statements while you are in custody with no ability to leave, essentially under arrest would qualify, and they're asking you questions actively about your participation in a crime. DUI would be one of them, absolutely. And then you utter a response. Lack of Miranda in that exact scenario is something to fight with. Otherwise, it is completely and utterly useless. The United States Supreme Court has actually held, so Miranda requires two things: custody and interrogation. Interrogation is easy. It's not, what's your name, how old are you, but where were you the night of the 16th? Boom, you have interrogation, that's all you need. If you volunteer information, that's not interrogation. Now, the second part, that's the tricky part, custody. When are you in custody? SCOTUS, the United States Supreme Court, has said that being stopped curbside is not custodial, period. So Miranda does not apply. There's no custody there. Because in theory, I guess these brilliant 9 men and women that we have in our Supreme Court think that you can just get up and leave. But to us lawyers, that's absolutely custody would just have, that argument has been crushed. But when you're back at the station, you will most likely not be read your Miranda rights once again. Because most of the time, they really don't ask you questions with the exception of how many beers you had, where were you going, where were you coming from. A lot of times, they'll completely circumvent the whole Miranda issue and just ask, I have some questions for you, do you mind answering? And most people just say, yeah, sure, what do you need? Then the next step that they'll do, that they have to say, is read you your implied consent. What is implied consent? Implied consent is this lengthy text, basically almost verbatim reading the statute. What happens if you refuse the test? What happens if you blow above a .08? What happens if you take the test? You have a right to your own test in that case, and blah, 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 blah. Once they're done with that, they have to wait 20 minutes. So from the time you walk in, they'll squeeze in the implied consent reading in the middle of that 20-minute period. But statutorily, they must have you under what's called present sense perception, basically viewing it to make sure you don't put anything in your mouth, you don't smoke, you don't eat, you don't drink, They're supposed to be watching for you not burping and not hiccuping or anything, because that can bring alcohol from the stomach back into the mouth region, which would artificially elevate your BA results. Most officers are not that keen on making sure you're not doing that. But that's what they're supposed to do. Once they're done reading, they'll ask, maybe, would you answer some questions? Would you like to? And one of the questions will be, would you like to contact an attorney? It must be, statutorily, it must be read. Failure to do that will subject the whole test to nullification. But most of them, they have like that text sitting right there in the BA room so that they will never miss it. Then they give you an option. If you take their test, you have a right to your own independent blood test. In my experience, good luck with that. Because they will drive you within reason, and there's a 2-hour period, which from the time of the stop to the time of the test must be done within that 2-hour period, whether it's their test or your own independent one. And good luck finding a hospital at 4 o'clock in the morning with a nurse that's going to give you a blood test. Sometimes it happens, and the one in Lexington, I think there's only one hospital that does it, and they said like $400 for a test, I think. And some of them will just refuse altogether. They won't even let you get one. So, but let's come back to our BA room. By the way, if you're in LMPD or LMDC, the Louisville Metro Department of Corrections, there's a little camera sitting there in the BA room that's recording everything you're doing. And as of 2 months ago, we now learned that there's a camera back here, which we now call the wall cam, which is recording basically everything that's happening in that room. They put it in for security purposes in 2013. Somehow they neglected to tell us about it. I wonder why. Well, anyway, we've learned about them. They have actually used video footage for investigation purposes to help one of their own. Who would have thought? And now we know about them, so now we're requesting them on all of our cases. They actually have cases which have already been resolved, and now they're coming back, and I mean, the county attorney is obviously objecting furiously to all of them, but it is what it is. So, finally, we come to the all-important question. Do you blow into this magical, majestic breathalyzer? Intoxilizer 5000 EN is what we're using. These things were manufactured for the first time back in like 1989, I want to say. This thing is a dinosaur. Okay, I mean it's technology that is extinct, but for some reason still thrives because the government just doesn't have any money. We've been trying to switch, or they've been trying to switch to the Intoxilizer 8000 for the last 7-8 years. I think now they're already starting to train BA techs in the 8000, but it hasn't rolled out yet, basically. But when you get the licensure, the officer will be licensed for both the 5000 and the 8000. Do you blow into this device? My recommendation, no matter how, even if you appear smashed on camera, is not to blow.
Not to blow.
my recommendation. Now, you can blow, and let's pick it apart just for a second. If you refuse, you really have two options, blow and not blow. If you do not blow and you refuse, you will be marked as a refusal that has its own consequences. It's not a violation in and of itself, but it has its own ramifications. What are they? Your license will be automatically suspended for 120 days. It's 30 to 120, but they usually max you out when you're on a refusal. You will get your license back. At the 120-day or 121-day mark, you can go to the DMV and get your license back if your case is still pending, or if it got dismissed or whatever. Even if your DUI gets dismissed, you can. I have tried to petition the court to get the license back, and it's about a 1 out of 2 chance you'll actually get your license back. It depends on the judge, depends on the case. So what I'm saying is the DUI has been dismissed maybe on the 3-month mark, and we still have a month to go, and the judge will make a determination whether they get their license back. Again, because the refusal has its own statutory consequences. And the second part of it is that the prosecutor can now use the refusal against you in court. They like this, what's called the consciousness of guilt argument. That section of the statute, basically the legislature in all 50 states back in the day, they were trying to figure out how to make people blow into the machine. Because in theory, you do not have you have a constitutional right not to provide evidence as evidence of your guilt for whatever crime you may or may not have committed. Fifth Amendment, that's it. You have a right to silence, basically. It's not in the Constitution, but that's what it is. And right to provide evidence. So they found a loophole to say, look, if you decide to refuse, which you have a right to, we're going to take your license away for the statutory maximum. And by the way, Kentucky, the legislature, I don't know if they passed it or not, they're trying to up the ante to, right now it's 30 days to 120. They're trying to change it from 6 months to 9 months. So you will lose your license for 9 months if this puppy passes. So, the refusal. Now, if you decide to blow, and you make the lawyer's case so much easier, especially if you look good on camera. Even if you refuse everything. I have a case right now pending. It's a guy in Fort Knox. I believe him. He said he was just scared shitless. He did not want to blow. He was scared as to what would happen. Now, the fact that the military is going to be taking care of him if and once they hear about it, that's a whole other thing. But for the court, he refused the breath. He refused he did take the field sobriety test, but he was nervous, which is completely fine. And then he refused the intoxilizer, and he refused everything with the exception of the field sobriety tests. And the case is great. It's a phenomenal case because the statute only permits the prosecutor to go one of 2 ways with regard to DUI. There are 2 elements. The first one is operation, easy, especially if you've been driving. The second element has 2 parts to it. First part is .08 or greater. So if they can prove operation plus .08 equals DUI, jury will find you guilty, most likely. And then the second part is officer testimony, observation, experience, etc., etc., etc. So basically they have to rely on the officer being believable, being credible, doing his job properly, and based on his experience. Yes?
Let's say you get in your car and you haven't put the keys in the ignition. I mean, I've heard 2 things, like, what you're gonna, like, no, I've never done this, left in my car somewhere.
Mm-hmm.
Should you, not put your keys in the ignition? Or does your car have to be running? I mean,
You can be standing outside of your car, approaching it, and the officer may stop and pop you for a DUI. Now, is your case as bad as the person driving? No. Are you still going to have the charges pending and probably need a lawyer and fight this in court? Yes. But is your case easier to beat? Also yes. Once again, it's just like with every case in the criminal or even civil realm, it all boils down to the facts. And if the facts are, I was seated in my car, and I had a case like this too. The girl was sleeping. The engine was on because it was March and it was cold, and she was trying to stay warm. She was not driving. Now the fact that because the case is already over, the fact that I know that she drove there, and then she was tired and she pulled over and she went to sleep, but we don't have to admit facts that hurt us in court. She went to bed in the car in the front seat, which, by the way, also, if you ever have to do that, go in the back seat. They can still arrest you for DUI, but again, you make the case a lot better.
Whoever was driving must have left. Maybe you're sleeping.
Yeah, the element of operation would be very hard to prove in that regard. The fact that you were planning to operate a vehicle is not an argument. Okay, mens rea, your mental state at the time is not admissible in court. It's only the actus reus. It's the act. So if I was planning on driving, I was planning on killing 10 people today. You know, you can't be prosecuted for murder or attempted murder. Anyway, does that answer your question?
Mhm.
Okay. Yes.
What is the increase, excuse me, in DUI arrests or convictions in the last 20, 25 years? I mean,
The
in my
statistical
time,
increase?
it was speeding tickets, speeding tickets, speeding tickets, speeding tickets. So was there an influx of an increase of drunk drivers that leads to this type of education about, well, here's what it is, and here's the pros and the cons, and this is what could happen? Has there been
Are
an
you asking me
increase?
why I do this?
Yes or no?
Oh, I do this because it's fun. I like educating the public about their rights.
Okay, so there's an increase in DUIs in the last 10, 20 years?
No.
Okay.
There has been an increase in officer response and active seeking of DUIs. It's a money thing. Speeding tickets used to be the big money generator. Now people, I don't know if they're not driving more carefully. It's just speeding tickets are the daytime, DUIs are the nighttime offense that their officers will readily admit, and I'm baffled by this, but they will readily admit that they actively driving around seeking DUIs. I'm like, officer, don't you have anything better to do? Like, don't you need to look for all offenses rather than actively sit there and watch the car that's doing this? I mean, how many times probably on my way here, I crossed the center line a couple of times. But because it's daytime, nobody's really paying attention to it. So I'm sure most of the people in this room, I mean, it's not uncommon, but at 4 o'clock in the morning, that offense is looked at. That violation, if you will, which is not even statutory. There is no KRS that says you touched the center line or the fog line, and now I can give you a ticket. But the fallback is the DUI if you do get popped for it. So no, there has been no increase, but there's been an increase because of the revenue stream. Each DUI that's a guilty plea to a first offense is $667 in court costs, service fee, and some other stuff that they include in there. So it's a big money maker. So going back to the intoxilizer, if you choose to blow, you made the prosecutor's case a lot easier. He now has his .08 if it's there, or if it's not, the statute actually reads if you're above the age of 21 and you blow below a .05, between a .02 or below is nothing. .02 to .049, there is a presumption that you are not under the influence. If you blow between a .05 and a .079, there is neither a presumption one way or another. However, if you blow .08 or above, this is what we like to call the DUI exception to the Constitution, there is a presumption of guilt. There's a presumption that you are under the influence. Now, how is that fair is beyond me. But this goes back to the days of communist Russia. You have to prove yourself innocent of the crime that you committed, otherwise you're going to jail. This is the only crime in the history of the United States to this day that is, you have to prove yourself innocent, and we are considering you guilty. So, again, my recommendation, if you have had, one drink over 2 hours, you did nothing wrong. You did not violate the law. You're within, alcohol is served wherever you go. And my recommendation, this is what I do, just to be safe, have a couple mints or gum or something to at least deflect. If you do get stopped, the officer, they don't really, I don't think they have an immediate, like, oh, you have gum in your mouth, you've probably been drinking, especially if you look fine. And you will look fine after, you know, a beer an hour or less, you know? Less than a beer an hour, I mean. The body processes a drink, the rough estimate is somewhere between 0.15 and 0.2 per hour. And it fluctuates dramatically from person to person. People have seen it as low as 0.003 per hour to as high as, I think it was like 0.35. So it all depends on the person. Now, the average is 0.5 to 0.02 to 0.015, excuse me, that's what I meant to say. So it fluctuates dramatically. So I guess what I'm trying to say is be safe. I'm not here, you know, to condone drinking and driving. If you have a drink and you feel fine, just be careful. It's all about your safety, officer safety. And once again, if you do come down to the situation where the officer is suspecting, even if you weren't, or if you were, field sobriety, I have failed, not in a police setting. A friend of mine who was a cop did field sobriety tests on me. I asked him, I was 0.000, and I've never done them before. I've read about them, but reading about them is not the same as doing them. I feel they're very unfair. I failed them. He said if you were on the street, I had probable cause to arrest you. And I asked him, and he told me, you know, the clues that they indicate, like raising your arms more than 6 inches from your waist as you're doing the walk the line, miscounting, turning improperly. I mean, you're supposed to turn like this. A lot of military personnel, I don't know if you've seen them. I mean, they do the military turn. You just gave them another clue. How is that fair? And second of all,
How are you supposed, you're not supposed to just spin around, you're supposed to make...
He's supposed to tell you what you're supposed to do, yeah,
Oh,
which is,
okay.
after you're done with your, you know, you do 7, 8, 9, you're supposed to kind of put your feet together and then turn around like this. That's what you're supposed to do, and he's supposed to tell you that. But NHTSA and our lovely men and women at the legislature thought that the way field sobriety tests are, like, why are they? I guess is the question. They explain them away as a divided attention test or tests. So how do they explain it? Now, let's say you're driving down the road. You got a few things going on at once, right? You're holding the wheel, you got the gas pedals, you're making sure that, oh, that car's getting a little too close to me. Okay, let me speed up a little bit. I'm watching forward. Okay, I need to make a left turn here. You're doing a lot of things at once, and your attention is divided between multiple tasks. That's why, I don't know if you guys know, a failure to turn on your headlights is one of the biggest reasons for a stop for DUI, because you're thinking about driving, you're not thinking, oh, it's dark out, I need to turn my lights on. And they, wherever they are, decided that to test divided attention, we will give you tests that they both involve balance, coordination, and I mean, you're speaking out loud, so you're doing a few things at once. But here's the kicker. Here's what I find fascinating, and I actually wrote an article about this. How many times have you all driven?
A lot.
A couple thousand, 20,000, 50,000 times? I don't know. I don't know the number. How many times have you all tried to perform field sobriety tests? Every morning, right? With my breakfast. Yeah. It's very unfair. The deck is stacked against you. And that is why I recommend never to do them. And any lawyer or police officer worth his salt will tell you not to do them because they're so volatile, once again. Yes?
I have a weird situation, 2 people that I know. One was in Indy, one was in Frankfurt. Unfortunately, they both got pulled over for drinking and driving on the same night, but 2 different cities. The guy in Indy refused everything. but was able to keep his license through the whole process. The guy that got pulled over in Frankfurt, he didn't refuse, he was well over drunk. Had to take classes, lost his license for 45 days. I know everything about the guy that got pulled over in Frankfurt, but the guy that got pulled over in Indy, a lot of us are still baffled as to how he was able to keep. Now, his girlfriend's an attorney. I don't know what type of attorney.
Ding, 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 ding.
Connections are very powerful.
But he completely refused everything. And and I know for specific reasons that he was able to keep his license, where the other person lost him until they got the classes completed and 45 days of no license. And it was just weird because the guy who kept his license was the one who refused.
I do not know Indiana law, but now you intrigue my curiosity, because to my knowledge, all 50 states of the union have an applied consent
Now,
statute.
is there a chance, depending on that person's job, that they can get a work release right away?
Out of jail, you mean? Or
No, they didn't go to
get the
jail.
license.
Oh.
To get your license, to be able to drive to work.
Okay, that's called a hardship license, what you're referring to. Those you may petition for at the 30-day mark, but it'll still be suspended. You'll just have like this little sheet of paper that's basically going to say, school 8 to 4, work, 6 to 12,
Right.
whatever. And if you get stopped and they ask for your license and registration, you just present that, I'm on a hardship, and it'll be signed by the judge. Or someone else with authority, basically. But the Kentucky case is the easiest one, you're right, to explain. He pled guilty, that's why he lost his license.
Right.
The statutory, for a plea of guilty, the statutory ramifications are, for a first offense, alcohol education program, it's going to be about 30 days.
Yep.
License suspension from anywhere from 30 to 120, depending on which county you're in. Hardin County is the absolute worst county. If you choose to get a DUI, the strangest phrase I've ever uttered in my life, don't do it in Hardin County, because you're going to get 120 days suspension after you plead. Jefferson County,
One more good reason not to go there. Yeah.
it's a terrible place. There's nothing to do there anyway.
Get
Classes, suspension, you will have to pay fines and costs, and if you blow above a .15, that's called an aggravator, for which you will have to serve either jail time, or if you're anywhere outside of Jeff, you will go to jail for 3 days, or 2 days, or 4 days, or whatever it is, depending on how many you've already served on your arrest. And if you've been in jail for like 6 hours, they still count it as 1 day. If you've been there for 25, they'll count it as 2, and so on.
Don't
Yes.
they have the option over here of putting the interlock on your car so your car won't start? unless you-
Yes, they do on a second offense or later, and it's very rarely exercised. I don't know why, but now with regard to I can't remember if the governor has signed this into law yet or not, but the new law that they rolled out is on a first offense aggravator. If you either have a child in the car, or you're speeding, child under 12, or you're speeding 30 miles or greater over the speed limit, I think those two, and there may be one more, then I think it becomes mandatory. And that's a brand new law. It's not even on the books yet. It's still being processed. It'll be either out July 1st or January 1st.
And depending on what you blow, I just know from going to get people out. The amount
I
of
got you.
time that you stay is based on what your alcohol level is. I know in Indiana it is. If you blow like point whatever, you have to stay, there's like a scale, so many hours for every.
Oh,
like-
quite possibly, yeah. I mean, they want you to
That's-
sober up before they're going to let you
Right,
out.
I mean,
Sure.
that's the way it is in Louisville too, and
Yeah.
they've got like a set time,
The
the
drunk tank.
earliest you can get out.
I've I've seen it.
Depending on what you, isn't that what
It's a
it is?
lovely place.
Oh, you've been in there?
Outside of it, thank you very much. I actually went on a tour of the whole jail. We had a girl that just completely had like a panic attack. She wasn't claustrophobic, but there's just something that overcomes a person. I got that feeling too. But, you know, you can't leave. Okay, once you're in, the only way out is you have to be escorted by an officer through like 17 double doors and whatnot. So anyway, yes, I was on tour and I saw the drunk tank from the outside. There was nobody in it. Any other questions? All right. Thank you all.
Thank you.